Good morning. This is Lex Radio. My name is Fatima Abimi and I'm your host for today. At Lex Radio, we've been following the NBA event and the NBA conference and the activities going on. And currently, there's a discussion around the paradigm shift happening in the judiciary with regard to the virtual space and the fact that we are entered into what they term the virtual judiciary age. And so, to further shed more light on this topic, we are going to be interviewing, have a conversation rather with an eminent lawyer, a very experienced one for that matter, in the name of Mrs. Boma Alabi OON, senior partner of Premier Africa Legal, and the former president of the Commonwealth Association of Lawyers. Good morning, Mrs. Alabi. It's good to have you here.
Good morning.
Thank you so much for honoring us and being able to participate in today's discussion. So like I mentioned, we've been talking about the NBA and the discussion going on about the judiciary and the shit going on there with regard to the use of the virtual space to legal proceeding. So my first question basically is, what do you think about all this thing? Do you think there's really been a shift, or it's just something, a temporary event that might change once the pandemic is over?
Well, in my view, the pandemic has created a new normal. I don't think that life is going to return to what it was before this pandemic. There's going to be a pre-pandemic life and post-pandemic life. We've already got used to, some of us who weren't used to this before, we've got used to virtual meetings. We've got used to finding other ways of doing things rather than being physically present. And that's become the new normal. So, for instance, last week there was a coup in Mali, as you know, and the ECOWAS heads of government had to have an emergency meeting. Usually they would all troop into Nigeria and stay physically at the Hilton and have that meeting in one of the conference rooms and so on. There was, yes, there's a barrier to international flights, but for heads of states, they can move. You can see Buhari, our president, went to traveled abroad and came back for a similar meeting. But guess what? They all stayed in their various countries and they had a virtual meeting. That's not happened ever before. So similarly with the courts, you're going to find that with new practice directions allowing us to serve even via WhatsApp, via email and so on, that they're not going to revert to it has to be physical service when this new normal is now in place. So it's a great step forward. It's here to stay and we all have to get used to it.
Thank you very much. It's here to stay, and we all have to get used to it. And that was an excellent example, the example of the what happened in Mali, and so that means we just have to get used to it, like you mentioned. So that takes me to the next question. I just stumbled on let's say a quotation that says the court is a service and not a place. So in the light of the argument on whether it's constitutional to have court proceedings in the virtual space, given the pressure that it has to be done within that physical court space, what's your take on that statement, the court is a service and not a place?
The court is a service, certainly. It can also be a place, which is what it's always been, but that service can be rendered virtually. So long as the judge is present, the judge is the court. He's the adjudicator, or she is the adjudicator. And if they're able to see, evaluate the evidence, hear the witnesses, be it virtually, then, the service can be delivered virtually. It's particularly important, as a matter of fact, that we see it as a service rather than a place when it comes to small claims and those sorts of things. Because, the process as it was inhibits the ability of claimants to bring forward small claims, and you find people resorting more to self-help which at the end of the day will lead and continues to lead to a deterioration of, the civilization in our society.
Excellent, thank you very much for that. So are you in any way suggesting that maybe the virtual space should be used exclusively for small claims while the larger claims should go to the fiscal courts?
No, not at all. Virtual space for small claims and similar things that are not too contentious. So even family law matters, for instance, matrimonial cases, and even for those matters that are highly contentious and require, full trial and so on, you can partially use virtual space to deal with. So the preliminary activities, filing of processes, ensuring that all of your, before issues are joined, you can use virtual space. Once issues are properly joined and you have to, witnesses have to give their testimony, examination in chief can be done virtually. Cross-examination can be done virtually. You don't have to be in the same room. You don't have to be in the courtroom. We can have a secure place. So it still requires a space, because when it comes to that, cross-examining the witness, it might be difficult to see and prevent manipulation or witness tampering or those sorts of things, if not somewhere where they can be physically properly seen. So we will have to think through the process, but it can be done.
So it's like a hybrid process. So the court is both a service as well as a place.
It is.
Thank you very much for that. But you seem very pro virtual judiciary age, and I'm wondering, don't you think there is infrastructural deficit that might make that difficult from the perspective of both the court as well as the litigants themselves?
I know that we have serious challenges with the infrastructure. I've been in the courtroom when the light's gone and the generator hasn't come on, and so on. But I believe it can be surmounted, which is why I'm consistently advocating for better funding for our judiciary. They shouldn't have to be judges, and particularly judges, because that's where they have to work. That's their day job. Shouldn't have to be in an environment where there's no light, there's, you can't put the fan on. I've been in courtrooms where the judges are so dedicated that no light, no generator, they use phones. The light from the phone to try and continue with the hearing.
Interesting.
Is disgraceful. So it can, there should be better funding for the judiciary. From the litigant's perspective, virtual hearings do not have to cost you any more than going to court, for instance. Yes, you may not have a laptop. There are business centers, there are cyber cafes, so the money you have spent on transport going to court, you can spend that on access to the virtual hearing in a cyber cafe or business center. There's one in literally every small town in Nigeria, so it doesn't have to be, you don't even have to have light or computer or anything in your home to access virtual court.
Excellent. So it's really not much of an additional cost to litigants.
I don't think so. I think it might actually work out cheaper for them.
It might. Great. And then another issue which I think has been going on in the international space, particularly is regard to data privacy, confidentiality, as well as access to justice. That before now, when we say open court, it was not envisaged that yes, the documents in the court are public documents, but we didn't have that impression that the entire universe, so to speak, would actually have access to those documents. What's your take on balancing open court or access to justice with issues of privacy, confidentiality, just have information that we would rather not have, the entire human race to have access to?
Once processes are filed in court, they are public documents. Anyone can access them. And the court sits, it's an open court. Anyone is welcome to come and sit down and watch proceedings. So there's no question of privacy in court proceedings, because it is actually the rule that the court must conduct its proceedings in public. Therefore, if it's virtual and it's open to all, it is precisely the right thing to be done. There are cases where vulnerable persons are involved, or children. Then arrangements are made for their privacy, because you don't want to name a child who's been molested or any of those sorts of things. That will be the same whether it's on a virtual hearing basis or not. So, but beyond that, I have no concerns about privacy or data protection, because the data is public.
Great, thank you for that explanation. So, would I call a closing remark from you now? Just general advice you probably have for both the judiciary and the lawyers, maybe as well as the government, what they can do to help navigate this shift or help ensure a smooth transition into the entire virtual space thing.
The government should give more resources to the judiciary. The executive and the legislative arm of government need to understand that the judiciary is the last hope of the common man. The judiciary is the foundation and it holds together the structure of our civilization. Without the rule of law, we might as well be living in a jungle. And that falls to the judiciary to administer. When they have issues, where do they go? To the courts. Everybody comes to the court for justice. Therefore, this is the most important arm of government and should be properly funded, because access to justice is a fundamental right. It's a fundamental human right. So to that extent, I would say better funding for the judiciary, and of course the Nigerian Bar Association has to play its role in advocating for that and pushing for the funding to be made available. On the part of the judiciary, I would say it's important that we get the right expertise to ensure that the process and the virtual service is delivered. And what other aspect did you want me to talk about? The
lawyers?
The lawyers? Well, these tools for us have always been something we use. It's commonplace. It's normal. I know there are some lawyers in the provinces or rural areas who are not used to even emails and those sorts of things. That has to change. This is 2020, not 1920. And everyone, there's no excuse. It's such an integral part of life that we just have to upskill.
Thank you very much for that. This is 2020, not 1920. So I think that's a takeaway for all lawyers. Thank you very much. It's such a pleasure to have you here. We're really honored and grateful that you've been able to enlighten us on this topic. Thank you so much.
You're
Mrs.
welcome.
Alabi, we're grateful.